Well, it's 10:30. That means it's time for Brainstorming the Human Connection. It's brought to you by the South Dakota Humanities Council. My name is Lawrence Diggs. I will be your host today. And we're going to be talking about copyright issues and other kind of intellectual property rights issues, probably the bigger umbrella that all of this goes under. Before we get started, however, I want to remind you that this is an interactive conversation. We have these conversations so that people can not only hear information that might be useful to them, but also have a chance to ask questions and involve everyone in a conversation. It's all about conversation. And it's not only that we learn better from conversations, but it also gives us a chance to practice having conversations in a civil manner and also in a safe manner, in a safe place where people can talk about ideas and get things cleared up without feeling like they're going to have an axe handle upside their head or something. It's just like, you just go easy, let the ideas wrestle with each other, and so we don't have to. That said, we'll get started. And today we have with us Katherine Cota, and she's the Director of Economic Development at Dakota State University. And she's also the Director of the Paulson Cyber Incubator and Entrepreneurial Center. And in those roles, she has become probably the state's expert on intellectual property concerns. She's, at least for me, the go-to person in this state to talk about those kind of issues. So today we're going to be exploring copyright issues. And if you're on Facebook, because I know some people, that's the way they're joining us on Facebook or some of the other platforms, please feel free to send us some questions if you have questions, and kind of join us through whatever platform you're on. With that, welcome, Katherine.
Thank you, Lawrence. I'm happy to be here, and I'm happy to talk with all of our creatives and artists out there.
Okay, so we'll get started, and let's first talk about let's learn a little bit about Katherine. I sort of introduced your titles, but titles often don't really tell you much. Tell us about Katherine. How did you get involved in this whole intellectual property rights thing? Did you start when you were 5 or 6? How did that come about?
So in 1996, I began working in Iowa for one of the John Papajohn Entrepreneurial Centers. As part of my work at the John Papajohn Entrepreneurial Center in Iowa, we dealt with helping people start small businesses, and we also dealt with the intellectual property and technology transfer. That's commercialization of stuff that faculty would create as part of their research or other types of activities. So having to be well-versed in the 4 areas of intellectual property became very, very important. And understanding when you use intellectual property, how you use intellectual property, how you protect it, and all of those things was essential. And so when I got hired in California, I continued to expand that knowledge, and now here in South Dakota. So for DSU, I am the intellectual property officer and the technology transfer manager, in addition to doing the work that I do in economic development and entrepreneurship here.
Mm-hmm. So what kind of things then do you do, as in those roles? What are your day-to-day activities look like?
So some of the stuff that I do specifically with intellectual property might be working with faculty members who have created something in a lab that we might potentially want to protect. It might be working with faculty members who have written a book and explaining to them how they can protect that book, how they can sell that book, all of those sorts of things. In addition to that, through my work through the Paulson Center, I work with all students, faculty, staff, and community entrepreneurs across the entire state of South Dakota on their entrepreneurial needs, which does include their intellectual property needs, which is why we're talking with all of you today.
Great. And we really appreciate that. And I'm hoping that we can answer some of the questions that many creatives have about their work. Under the rubric of intellectual property rights, there are sort of like broad categories. Can you talk about that for us and kind of clue us in on how all of those different intellectual property rights are divided up?
So Lawrence, I'm going to do a screen share with you right now. And
Okay,
we're
great.
actually going to hope everybody can see the screen. Yes.
I can see
All
it.
right. Thank you, Colby, for the nod. I appreciate that. So let's understand what intellectual property is. So it's anything that comes to us as a product of the human intellect for which we have the ability to determine its commercial value. So as we can see, these could be things like our songs, our artworks, our paintings, our photographs, could be things like mechanical inventions that we create, could be software, any of a number of things. Our commercial value, the commercial value is our ability as the creator of that to control how that is going to be used. So that's really important to understand what intellectual property is. There are 4 types of intellectual property. But before we get to those, what we need to understand is the law tells us, the intellectual property laws give us the right to sell or license what we have created to other people, to other companies. We get to make that determination as the creator. The law also helps us settle disputes of our intellectual property. And then finally, the law allows for enhanced protection for us of what it is that we create. What the law does not allow is it offers affirmative rights, not protection. In other words, that means there are no intellectual property police running around out there protecting your photograph from being used by someone else. So you as the creator of that photograph, the photographer who took that photograph, you have to protect the use of that photograph and determine who has the right to its commercial value. So when we do certain things like filing with the copyright.gov through the United States Library of Congress, filing that copyright on that photograph, that provides us with enhanced protection. And so we are able in a court to prove that that is our intellectual property and that we control its use. So there are 4 types of intellectual property. The 4 types of property are trade secrets. If it's a secret, you need to keep it secret. You don't put that secret out there or it ceases to be a secret. Things that are often trade secreted include formulas, include recipes. So Coca-Cola is a very famous trade secret formula. We use a number of legal documents to keep trade secrets secret, but we're not talking about trade secrets today. We're not also going to talk about patents today. Patents are issued through the United States Patent and Trademark Office for physical objects, things that we can actually create. And their patents are issued for manufacturing and for processing. We're not going to cover those today. Trademarks, if you're a graphic designer, you may be trademarking as part of that work that you do for there. And so we'll briefly cover a little bit on trademarks. But the big one that most creatives actually use is copyrights. And copyrights are, do you want me to continue on, Lawrence, or did you have
go
another
ahead.
question at this point?
Go
Okay.
ahead. I think that's great. Go ahead.
Okay, so we're going to talk about copyrights. So what a copyright actually allows us to do is protect our creative work. You get something called a de facto or an automatic copyright if you put the little copyright bug, the little C in a circle, on the work that you have created. And so that is a simple copyright. If you want true protection, especially for commercial use, you're going to sell this, you want to be able to license it to someone to use in a book or in a video game or some other way. You want to benefit from what you have created. You're going to want to do what's called enhanced copyright protection. In other words, you're filing through the U.S. Copyright Office, copyright.gov. We'll go there in a minute. That filing, that enhanced protection, stands up in court. Should someone use your materials without your permission, then you can take them to court. And by having that enhanced copyright, pardon me, by having that enhanced copyright, you will have a good standing in a court of law. So what I often get asked at this particular point is, well, Katherine, what about mailing it to myself through the United States Postal Service? We call that in the law a poor man's copyright. And here's the deal with that. It doesn't work. So in a court case, that poor man's copyright, I mailed a copy of it to myself, does not work and does not stand up in court. The only copyright protections that stand up in court that protect your right to full commercial use of what it is that you have created is the enhanced protection that you file through the Library of Congress's Copyright Office. So, the thing a judge would say to you in court, if you were in court, is, and this is what judges always say, and they say the same thing for trademarks too. If you care about it and you wanted to control its commercial use, you needed to protect it. And that is where the law comes in, that if you want to commercialize this, or you want to protect this, or you want to maintain that this is truly yours, be it a trademarkable item, be it a copyrightable item, then you must protect it. That would be for a trademark, filing through the U.S. Patent and Trademark Office. We can take a look there in just a second. Or for a copyrighted material through the U.S. Copyright Office. So a couple more quick thoughts before we pop over to the U.S. Copyright Office. When you are creating a work that you are going to copyright, it must be in a fixed form. That is the legal term that we use. That means it's in a form of actual expression. It is not an idea. So physically, you must paint the painting. Physically, you must photograph the photograph. Physically, you must write the book. So you cannot copyright an idea. You can only copyright the expression of that idea. The book you have written, the painting you have painted, the photograph you have photographed, the software you have written. Those items that you have fixed in a tangible form, the book you have just now finished writing, the photograph you have just taken, the painting you have just painted, you must file for that copyright protection within 3 months of having fixed it in a tangible form. So we always keep in mind when we are finishing our work, whatever that work is, if we're going to file for the enhanced protection, we need to file within 3 months of fixing it in that form for the protection. I'll pause
So
right
question,
now. I'll pause
yeah.
right now for comments or questions.
So the question that comes to mind for me is, first of all, if you have a, let's say you have an idea and then you write the idea down, or even if you don't write it down, you perform it. Okay. So if you perform it, it's not exactly in a fixed form. So when does it count to be a fixed form?
So in performance art, you've got some different ways of protecting that. So are you scripting your performance piece?
Well, if
This-
they're like, okay,
this-
so let's say, for example, if you're a rap artist, often they don't, they memorize all their things, and sometimes it's actually impromptu,
Right. So if we record that rap, we've now
Okay.
fixed it in a tangible form. If
Right.
we write that rap down or somebody transcribes that rap for us, it is now fixed in a tangible form. So even performance artists can have some ability to protect what it is that they're creating if we can capture it in a medium of fixed
Yeah.
format.
Right. So I bring this up because often one of the art forms, with rap music and that kind of performance is sometimes people will just give a cue, like they will give a prompt, they will say something, and then that person will think about it for a moment, or sometimes immediately they will come up on the fly with a rap, something. Okay. So they have not really put it in a fixed form, but they have put their own intellectual capabilities into creating that piece. Are they just sort of
And so
out
Lawrence,
there?
I'm gonna take you back a step to the discussion we
Okay.
just had. The
Okay.
other part of the intellectual property is your ability to control its commercial value. So an artist can create something in the moment, but if you want to use that for commercial value, you have to think of how you're going to use that for commercial value. So a rapper could rap something in that moment, but if that rapper wants to use that commercial value aspect of intellectual property, then maybe they're recording it into an album or a CD, or maybe they're recording a video that's going to be posted out on YouTube or some other medium. Those are taking that in the moment thing and then putting it in a medium that it can be used for commercial value.
Okay. So if John Doe or Jane Doe is in the audience and they use their phone to record your impromptu rap and then post it on YouTube, does that, I mean, now it's in a fixed form. You didn't fix it. It's out there, and it doesn't have a C or anything on it.
Right.
Nobody's claimed it. So how does that work?
So that's where many artists will limit people from recording their particular works as much as, I've been to many a show where I've had artists say, don't record this. I've been to many a show where I say, please share these bits and pieces.
Right.
You as the artist have to make your determination what your objective is. So perhaps that artist doesn't necessarily want to protect the intellectual property to expand their potential, to expand that artist's potential audience, to gain more recognition, which could lead to other beneficial commercial values and other things they can do later on. So you have to be very strategic about how you're thinking about what this thing is, but how it fits into your entire portfolio. I see we had a question pop up in the chat. How do you know if something is in the public domain? So public domain is public domain. automatically happens after the death of the original creator. So when you're issued a copyright, it's your life plus 70 years. So the death of the original creator plus 70 years will then put something into the public domain. So that's your rule of thumb. That's why things like Mozart's music can now be used by so many entities, because Mozart has been dead beyond his life and 70 years. So for public domain, as a general rule, death of the creator plus 70 years. You can create something now that you choose to put in the public domain. So Creative Commons is a website that has a lot of stuff where creatives have created stuff and put it there for folks to use in the public domain. So those are a couple of ways to quickly answer that question. We've got a question here about, looks like a book has been sent to a publisher. If you are sending a book to a publisher and working with a publisher, that publisher will be the one to file that copyright. You generally are going to have contract with the publisher regarding that piece of creative work that you're doing. That's going to lay out who has the rights of use, what you're going to be paid for this particular book. And generally the publisher is going to be the one that is going to copyright that particular work. Would you? So no, you would not necessarily copyright it before sending if this is a work that you are creating in conjunction with an agreement with the publisher. If this is a work that you have done at some earlier point and you have protected it, and now a publisher has interest in it, then that is a different type of license and a different type of copyright that you're going to negotiate in. So if you were concurrently working with a publisher on a piece that you are creating at that moment with that publisher, the publisher is going to be the one that's going to handle the copywriting of that creative work. If you are not doing that at that point, you may then choose to protect your own work, and then maybe you get a licensing deal at a later point.
Right. So I think to get back to that question, it sounded like the question was like, I'm a writer. I don't have a market. I don't have a contract to put out so many books with I don't even have a relationship with a publisher, but I'm a writer, and I want to shop the piece. In other words, I'm going to send it around, go to a conference, and I want to see if anybody's interested in it. If I can get it published, do I need to copyright that before I start shopping it around? And yeah.
So you may choose to do the enhanced protection. It's certainly an option. You may choose to just do the copyright bug, claiming the copyright, my original expression of this, if you are in the process of shopping this around. Again, you have some options here. There is no hard or fast rule. It's what you're trying to do. So you may have a copyright, and you may choose to enhance that copyright by filing with the Copyright Office. If you find a publisher then who is interested in that book, you would then license your copyright to that publisher, who could then print that book and would do their own copywriting on that fixed book that they're going to print and have available. So
thank you, Lauren. This is Deb, and that's kind of the question I was going for. But I'm thinking now, if you're just shopping with a manuscript, sending them out to different publishers, and 3 months have passed and you haven't heard from anyone, where does that leave you?
So what I tell my creatives, and what I've been known to do in my works too, is I go in and I change just a few things in it, which makes it then a derivative work from the original work. And now that has started your clock again on the 3 months.
Thank you.
You're welcome. So that's a way of getting around that 3 months. But to Deb's point and to Deb's question, if she's created this book and she knows she wants to shop it around to publishers, and we know that we've got that 3-month deadline, it actually benefits you to pay the $35 fee that we've got at copyright.gov, which I've now pulled up on the screen for you, to pay the $35 fee so that you've got that protection and you don't have to play games like making a derivative work from that.
But you
So
still could change it if you wanted to, or not.
So-
It would be set in stone pretty much after it's been copyrighted, licensed.
After it's been copyrighted, then that work is done. That's a copyright. So anything that you would do that might be that, but a little different, is what we call a derivative work. So it's not uncommon to have certain works where you might have an original, and then there are other works that you create later that are sort of based off of that original theme, are derivatives of that original theme. I know as a painter, I do that quite a bit. So I may come up with a first painting that I really like, and I like the concept. So I may create other derivative works of that, things that are in that same sort of theme, that same sort of category. Does that help, Deb?
Yes, and it makes me think then if you have a second edition of a book that's been published and you've made some changes in the second edition, that kind of follows that you have to copyright that again then?
Yep. The second edition, if you've made any changes, is going to be a new copyright.
Thank you. Excellent.
I pulled up the copyright.gov website for everyone. Let me show you a few simple things on here that are going to benefit you. So it's copyright.gov, and I believe Colby has thrown that URL into the chat for you. Copyright.gov. This is through the Library of Congress. They've got a quick learn more here, and it's going to go over everything that you need to know about what copyrights do. There's how you search for copyrights, how you record them, what the law says, the fees, all of that. You're going to want to go here and register your works. And so we're going to pop in there. And what they are warning us here at the top about is if we're creating a group of unpublished works, that we can only put 10 works at a time under one application for copyright. So that's just their little warning up here. And that the standard application cannot be used to register a collection of works. Yes.
So so how about in the case, let's say, of an album, a musical album, which one could say is kind of like chapters in a book, but I don't know how the copyright folks see it. If you're doing an album and you have 20 songs, do you have to do 2 copyrights?
So again, Lawrence, that would come here under performing arts, sound recordings. We can pop in and learn more. And then you're going to be given the definition. You're going to be given how you fill out the application, single, group, works of performing arts, sound recordings. This site is going to give you pre-registering your music. This site is going to give you the specifics of how you would group those things together, which application you're going to file. That's why I always refer people here to the copyright.gov site, because they've got it all laid out for all of the different types of creative works. I'm going to take a step back, going back to the types of works. And we can see here, we've got our literary works. So our fiction, our nonfiction, poetry, periodicals. We've got our performing arts. So our music, lyrics, recordings, scripts, plays. We've got our visual arts. So artwork, illustration, jewelry, fabric, architecture. This is our computer programmings, websites, blogs, databases. We've got motion pictures, TV, video games, animation and videos. And then we've got our photography of all of the different types of photography. So you can pop into each one of these different learn more sections for the type of creative work that you have. And then you can find out which application you need to file and the specifics of how you file that application. Most of these applications are about 2 pages long, really quite simple when it comes down to it. It's $35 filing fee per application, unless they've raised it since the last time I looked, but roughly $35 application fee for each of the applications to protect your work. And you submit an actual copy of the work when you file the application online. So they have to have something that they can put into the Library of Congress archives. Questions on that?
Anybody have questions?
I see something has popped up in the chat. I have some questions concerning artwork. I'm to sale with a. Okay, so thank you, Angie, for your question. That brings up a point here. I am happy to, because intellectual property is so unique and so specific, especially when it comes to these types of creative works. All of them have nuances. Folks can feel free to send me an email and I'll happily schedule an in-person meeting or a Zoom meeting. And we can talk through the pros and cons of protecting that or not protecting that and which mechanism to use. So we can throw into my chat my email address, if we could, Colby, and folks can easily contact me. Phone calls don't always work so well because I'm traveling and teaching and on the road a whole lot and in a lot of meetings. So email is always a better. So it is Katherine.Cota@dsu.edu. And I think Colby's going to throw that into the chat. There we go. Perfect. Thank you so much, Colby. All right, Lawrence.
Okay, so what kind of let's say problems come up often with artists, especially let's talk about visual artists, for example. They're always, having their sketchbooks or books that they're working on, their pieces, and so they can, when they can be quite prolific even if they're not putting out stuff. So I could see that this kind of workflow could create some interesting problems for copywriting for visual artists. Can you talk about what kind of issues you've seen pop up?
So Lawrence, as a photographer and as a painter, obviously I create a lot of works, right? I do not protect them all. So I pick and choose what pieces I do that I know I'm really going to put out on a public stage. So for example, if I'm entering a couple of pieces into an artist competition, I will protect those. That just makes sense because now I'm putting it out in a format where it can have a lot more exposure. So I don't protect everything I create. That would just become too cost prohibitive. But for stuff that you're going to actually utilize, for stuff that you're going to put out there in some sort of format, you publicly, a competition, a gallery, those sorts of things for sale, you might definitely want to protect. Then you think about protecting. For visual artists, what we often run into is the following. Often our work winds up appearing on the internet, on websites without our permission, on social media without our permission, on various formats without our permission. We, as the creator of that and the holder of its right to commercial use, have to then protect that. So I know I have had to help clients write letters of cease and desist, stop using my piece, you don't have permission to do it. I've helped clients who have written agreements so that others can use their pieces. So again, that's controlling the use of who has it. I have also been on the other side of that, working with clients who have violated someone else's copyright by pulling down their particular artwork or their visual something and just used it without the permission. So, you know, they've received a cease and desist letter, and it has said, you violated the use of my creative work. Yeah, I need you to send me a $600 check or whatever the commercial value is they have determined for that. So there are many sides to this, but the gist of it is you as the creative need to protect works you're going to be putting out in some format where others might use them. And you as the creative are responsible for protecting the use of that and who has access to that. So while I may create and have a huge portfolio of all kinds of works that I may show somebody, you know, a book of photographs that I have done, my portfolio of photographs, the only ones I might protect are the ones that they would then say, well, I want to license this one and this one and this one for use on this particular website, for use in this particular book. And so those would be the ones that I would choose to protect.
So in a case like that, and we have a question in the chat, but I will get back to that. But in a case like, let's say you have a whole bunch of photographs, if you put them into a book and you copyrighted that book, are all the photographs in that book copywritten or copyrighted, or just do you have to do 10 photographs at a time?
So again, we're going back to that fixed in a tangible format. So the process of compiling, for example, words and pictures and perhaps drawings and those sorts of things together into that book, you are copywriting that entire creative work and all of its elements together. Could you have in that book a rendering, a drawing that you had created at a previous point and protected appear in that book? Yes, you can, especially if it's your work in your own book. If it's someone else's book, you're going to have to license that from the original creator to include it in your book because they're the creator of that. So the book is the entire compilation of everything that's in there is copyrighted under that copyright for the book.
Okay, so now if I get back to, let's say, musical things, you know, does it work the same thing? I mean, you have a large album and it's a collection
So it's
all your pieces.
Yep. So book, everything there, and without going in and checking the specifics on how they're now talking about compilations, which I have not done yet. In the way I've always understood it, if you're putting those individual pieces together as an entire unit, then that is the album, and you're doing the album with those 20 songs.
Right. So can you then license one of the songs, or you have to license the whole book or a whole album?
You are the creator of that intellectual property and the holder of that. As the creator and the holder of who controls its commercial use, you have the right to determine if you're going to license a whole, a part, a fraction of a part, a fraction of a fraction of a part, and then what the price for that is. So you determine the commercial value of that. And so in the agreement that you're going to be writing, obviously with legal help or the Paulson Center or some other entity helping you, you get the right to determine who is using this, what they are using of my creative, how much they can use, when and how they can use it, and when they can no longer use it, and what price they're paying me while they are using it. So those
Okay.
would be elements in your license agreement.
Great. So our question from John is, he says, I've seen several consecutive copyrights on written material. Can anyone get or assert a copyright on something once copyrighted, but not copyrighted again? I'm not. John, you might have to explain exactly what you mean here. That question's not, at least, unless you understand it different, Catherine. I'm kind of.
Consecutive copyrights on written material. Oh, okay. So he might be talking about when you see, for example, books that are published, and then you see copyright 2021, 2008, 2013, etc. So that would be the consecutive copyrights on materials. Can anyone get or assert a copyright on something once copyrighted, but not copyrighted again? I'm
That's the
not
part I don't
quite
get.
understanding
Yeah,
that.
that's what I don't get.
That part of the
Yeah.
question.
John, you want to unmic and try to explain what you meant? Might be too shy.
So
But,
again,
all right.
as the original creator of a piece and the creator of those derivative pieces, you have the right to protect those pieces. And that could mean the original, and each of those particular derivatives that you have could mean, depending upon what you're copywriting, you might have multiple copyrights on bits or parts or the whole work. I'm trying my best to try to figure out what we might be getting to at that part of the question.
Yeah. Well, John didn't come back on, so I don't know, maybe we answered his question or he's trying to figure it out too. Because sometimes a person will have a question, but it's not, the question is because the question is not clear. You know, it's like, okay, how does all of this stuff work? You know, so he might be thinking about it. We'll let it go, and he's thinking about it. Okay, so are there other things that artists sort of work themselves into a corner or forget to do, or problems that have popped up, things that you have worked on to help people straighten out? What kind of problems come up?
So the most common thing that artists and creatives don't do is failing to think about their creative works in a business-like or strategic fashion. What I mean by that is artists often are so involved in the creating of that painting or the photographs that they're taking or the book that they're writing, that they forget about the commercial value side of what it is that they're doing, and they forget to do those protections of that work at the beginning, when they're creating that, and fail to think about that when they're creating that. And then that piece gets out, or the photographs get out, or the book is now ready, or those sorts of things. And someone infringes, someone uses part of that creative work. And now the artist is upset because someone is using that creative work and benefiting from it, and they're not getting the value from it, or they're not getting the credit or the recognition from it. So the first thing is artists have to start thinking about, how do I want to use this work? Where do I want to place this work? Who do I want to see this work? And how do I want to protect this work so I am the one that is making the determination on where it's going to be placed, how it's going to be used, etc. Some of the worst things that can happen are when an artist or creative has a work, and I'm thinking right now of visual works of a work taken from them and used especially in a negative context, that can be really awful. And so to prevent that, somebody using a really good photograph of yours and putting a bad message behind it can be emotionally difficult, as well as artistically difficult, and certainly financially difficult. So a little forethought on, is this a work I'm going to put out there? Therefore, should I be protecting it? You have the right to do the enhanced protection by filing at copyright.gov. You have the right to choose not to file at copyright.gov. So on a lot of the materials that I create here, the documents I write, the PowerPoints I put together for teaching materials, you'll see on the bottom that I choose to put the de facto copyright, the C in the circle, the copyright bug, and I put my name and I put my date. And then I put a clause out after that that says, for your personal educational purposes, and thus allowing people to use my materials for themselves individually without financially compensating me. Then there is a second line on there that's very specific that tells people if they want to use this in a class, in a training, in a book that they're writing, or other things like that, then they must contact me for a license and permission. So I grant many of the materials that I have created and many of the works I've created to each individual. I grant you, Lawrence, the right to use this document from me so that for your own personal edification. But I don't let you use that when you're going out and consulting with other groups around the state unless you license it with me and I've received some sort of compensation.
Great. John kind of followed up on his question. He said, you said a copyright exists for 70 years from the death of the creator. If that time frame expires and there's no successive copyright claim to that piece of work, can someone then copyright that work?
So that work is what's called in the public domain, and that allows you to use a portion of that work or parts of that work in something that you would create. But you cannot take the entirety of the whole work and recopyright it yourself as a general rule. That is not you being creative, but can you use parts of that in your own work? Absolutely.
Yeah, I think his question, I'm not sure if this is what he had in mind, but it sort of speaks to sometimes people will take something that's in the public domain. The book just went out of print and they reprint it. And sometimes they will put a copyright thing on their sort of reintroduction of that material.
Yes.
But usually that copyright only, as I understand it, and give me some feedback here. I understand that it only applies to you putting that thing together. All the public domain stuff is still in the public domain, and anybody else can like say, oh, that's a good idea, that's a good market, I can go and take that same book and it's like copyrighting the Bible. We can, we can once it's out there,
Yep. Yeah. So oftentimes you'll see reprint of or reissue of or something along those to let folks know that, again, it's a new printing of this old source material. You are not the original creator of the material. The original Mozart still composed the symphonies Mozart composed, and we have to give him credit. We may reissue those songs and put them out there again. They are in the public domain, but he was the original creator for it. So it doesn't change the base work. The Bible does not change. Those who wrote it, right? And
they've been dead a couple of more years than 70.
And they've been dead a couple of more years than 70. But we can certainly do a reprint of that particular source material.
Right. So this comes, another question that this brings up is things that are not copyrightable that people may not know. For example, chords to a song there's, maybe some chord changes that you could just like play those chord changes and sing 50 songs and never change the chord changes. So can you talk a little bit about the kind of things that people may not know that you actually can't copyright that?
So in all forms of intellectual property, there are certain things that are set aside that cannot be protected because they are base to what that is. So in patenting, for example, you can't patent naturally occurring substances. We didn't originally create them. I mean, carbon is carbon. It's a base substance. Oxygen is oxygen. It's a base substance. So each form of intellectual property has something that is a base that you cannot protect because everybody has that and has access to that.
Well, and one point along that line, it's probably been around. Carbon has been around longer than it would be patentable anyway.
Yes.
Hey, this is Deb again, and I have a question along those lines. Say I'm a band, I'm part of a band, and I want to cover a song that's in the public domain, but I'm going to stylize it in my own stylistics.
Mhm.
And I want to put it in a CD that I'm creating.
Mhm.
So I can't copyright it because I've used the original, but I've changed it. So can I copyright it, or how does that work?
So again, you said it was in the public domain. So that part that is in the public domain, you can use. And now you are making your own work that has other elements that are creative to you that add on to that which is in the public domain. So you can copyright what you are doing. So that part of the song that appears in your song is part of that. You just don't own that part of the song. You've copyrighted it as part of a work that you have created. Does that make sense to you, Deb?
Yes, so I could use that in a CD and sell it.
Absolutely.
Yes.
It's in the
right.
public domain. If it were not in the public domain, you would have to get permission from or a license from the original creator to be able to use that piece in your particular work. So we get a lot of that when we see court cases where somebody has sampled something of someone else's song and has put that into their own song. And so that's why you've seen a lot of litigation lately. Ed Sheeran recently, and I can't even think of who else wound up doing that. But that's what that is over. Is Ed is still alive. Ed is still writing music. So Ed is not dead plus 70 years. So anybody who wants to use something he's originally created needs to license from him. If you're in public domain, death plus 70, you're fine for using that creative work into your creative work.
Thank you.
So how about in Deb's case, how about the arrangement? Because I know when you're actually publishing music or you're putting music out, there's all these different things of like, what do you have the rights to, mechanicals and arrangement and all of that. How does that play with copyright? Can you copyright an arrangement or?
Yep. So if you look right under, I'm not sharing anymore, Lawrence. Bad on me. All right, let's see. We're back here. So if we're back here in the copyright.gov site, and we're looking at our different types of works, here under performing arts, we can actually see sheet music here. So you can submit your own sheet music or other ways, demos or whatever you might be doing, actual recordings of what you're doing. You can submit those particular works in for copywriting. So you can see we've got compositions here, we've got recordings here, we've got performances in here. Does that help with that question?
I hope so. Okay, so we're getting near the end of our time here. We only got about 5 or so minutes. are there some things that we want to make sure? Oh, we didn't really actually cover the thing with the chords. Can you tell us, or I feel like completely it wasn't completely covered. We got kind of sidetracked. Are there other things like chords that you would think you might think could be copyrighted, but because of how the copyright law works, not so much?
I'd have to go to all of my resource materials and go through to find
Okay.
exactly what can and can't with regard to copyrights. The ones I am automatically familiar with off the top of my head, because I deal with them more, are in the patent realm because I'm doing so many
Okay.
patents and stuff.
Okay.
Copyrights
Okay.
a little more nuanced for than I regularly deal with, but I've certainly got reference materials that I could go to and find those answers. I just don't have that for you right off the bat.
Okay, cool. So are there things that we want to make sure that we get covered that we might not have about copyrights? Because I know that there are like lots of little traps sometimes that, you know, people think, oh, I don't have to have a copyright for that, or I do. Anything we're missing that we didn't cover that you can think of? I have a couple other things I want to cover, but I want to cover that.
Copyrights are actually the simplest of the different forms of intellectual property. And so copyrights are the ones that an individual, a creator, can do themselves. So you can file your own application at copyright.gov. You can pay the $35 fee. It's a 2-sheet form. You submit your sample. Very simple. If we're dealing with patents or trademarks, I really recommend that someone work with our office or our center or another center that has the ability to handle intellectual property and advise accordingly, or an attorney that specializes in patents and trademarks, because these are a lot more complicated and there are a lot more things to think about in the patent and trademark realm. Copyrights, creators can generally handle this on their own.
Okay. Betty, you look like you have a question, that question mark look on your face.
Thank you, Lawrence. This is a very interesting program, and my question, I'm sure, is very simple. I've never really considered copywriting my work. I'm a visual artist primarily, and I have been painting for years. I'm considering, and I've never copyrighted, as I said. So if I were going to compile those into a picture book, copyright that book as an entity or, you know, a work, then would that be the way to cover myself on that?
So if you are going to compile them into a book, Betty, then you are going to copyright the book, and then that protects all of the material that is in there. As a visual artist myself, what I wind up doing is, when I know I'm putting, for example, 2 photographs or a painting and a photograph into some sort of a competition, then I will protect those 2. As I'm, I'm sure you, like I, when you take something and you get an occasional photo or you do an occasional painting, you go, wow, that's really good. And you actually surprise yourself, right? When I get that, wow, that's really good, and I know in my brain I'm probably entering that in some sort of competition, I will then immediately protect that when I fix that photograph, or when I fix that painting and in its final form. Because we've got that 3-month deadline. So if I get that, wow, you know, that surprised myself that I've created this great thing, those are usually the ones I know that I'm going to want to put out there. And so I will protect those in some way. But
this brings up another point. So because I'm sunk as far as the 3-month limit right now with what I have, but say I put those into a book and then I want to take that one wow painting out, will it still be, do I have to protect it again, or can I protect it?
What you can do, Betty, then is you come up with a beautiful way to get around that 3-month deadline, right? By putting them together into the book, right? And now you're going to go ahead and copyright that book that you have put together. So when you want to use that one painting that's out of that 3-month deadline, or that one photograph,
Mhm.
you can license the use of that particular piece
Okay,
in future stuff because you've already protected it now as part of that book.
okay,
So
and
we
that
get
would
we
be,
get a little creative in how we do some of this stuff, right? We're creatives.
Right.
Let's get creative.
Right,
so.
and so with that, we're actually at 11:30. We're gonna have to,
Thank you.
have to pick this up another time, but excellent discussion. Thank you very much, Catherine, for joining us, and we hope you'll come back again sometime and we can pick up on Betty's question. Hold that thought, Betty.
Happy to help anyone.
Okay.
Thank you all.
All right. Thank you very much, everyone. Remember, you can copy, the chat by going down and, looking at those 3 little dots on the bottom. Click on it and save the chat, and then you'll have all of the contact information. Thanks. Next time, see you next time, same station, same time. Bye.